Hi, my name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about the appointment process for the US Supreme Court in Edexcel A-Level Politics. I'm going to start by looking at the parts of the specification this video covers and the key potential essay questions that you could get asked on it in the exam. I'm then going to give you an introduction to the appointment process, looking at how it works, examples of the appointment process, and how it's increasingly politicised. I'm then going to look at the factors that the President takes into account when choosing nominees, the strengths and weaknesses of the appointment process, how the ideological balance of the court has changed over time, and the current composition and ideological balance of the court. The PDF you can see on your screen is part of an updated US Edexcel A-Level Politics textbook on the US side of the course that you can purchase on the Politics Explained website, where you can also find loads of other essay plans and resources to help you in your Politics A-Level, and a place to sign up for tutoring if that's something you'd be interested in. Let me know if you've got any questions or comments, if anything comes up throughout the video. Without further ado, let's get into it. So starting with the parts of the specification this lesson covers. So this is 4.2 of the Edexcel US side of the course, looking at the appointment process for the Supreme Court, strengths and weaknesses, factors influencing the President's choice of nominees, and the current composition and ideological balance of the court. This will be really useful in lots of the 12 markers and 30 markers you can get asked on the Supreme Court in particular, looking at the differences in the UK and US Supreme Courts. You can even get a question comparing the differences in the appointment process potentially. That's a bit less likely, but the appointment process could definitely be a comparative one of the paragraphs in a lot of these 12 markers. Looking at kind of differences in the membership and tenure, or similarities or differences, similarities or differences in their powers and their independence, or lots of just maybe a general one, similarities and differences between the UK and the US Supreme Courts. And you're also very much going to bring this in onto a lot of the questions, the 30 marks you could get asked. So you could get a question just on the appointment process. So evaluate the view that the Supreme Court appointment process has been or is ineffective or is effective potentially. You could bring it into questions about whether there's an imperial judiciary, whether the court is political rather than judicial, and potentially also in relation to its influence on public policy in recent decades. And knowing some of these key members of the Supreme Court can be really useful for these 30 markers, as well as the 12 markers. So yeah, starting off, we're going to have a look at the appointment process itself and how it works. So the first key step is that a vacancy occurs, and this is when either an existing member of the Supreme Court either dies, retires, or there's kind of the impeachment of a justice, though that hasn't ever occurred. So, for example, in 2020, Ruth Bader Ginsburg died, and Anthony Kennedy retired in 2018. Then it goes to the President's nomination. So the President has a responsibility to nominate a candidate for the vacancy, and this candidacy is usually selected after a period of consultation and consideration, often involving legal experts, advisors, and sometimes public opinion. While there are no formal criteria set for Supreme Court justice in the Constitution, nominees typically have extensive legal experience, often as judges, lawyers, or legal scholars. It then goes to the Senate Judiciary Committee once that nomination has been made, and there are hearings. So once the President nominates a candidate, the nomination is sent to the Senate Judiciary Committee, and the committee holds hearings where the nominee is questioned about their legal philosophy, past judicial decisions, opinions on constitutional matters, and other relevant topics. Amy Coney Barrett's 2020 hearings were notably quick, reflecting the urgency of the Republicans to appoint her before the 2020 election. After the hearings, the committee votes to recommend the nominee to the full Senate for approval or rejection, and they may also choose to make no recommendation. It then goes to the Senate the full Senate for a vote. So the full Senate debates the nomination, senators discuss the nominee's qualifications, judicial philosophy, and other important issues. And then there's a vote, and for the nominee to be appointed to the Supreme Court, a majority of the Senate must vote in favour of the nomination. The required majority has historically been a simple majority, but rules and political strategies can affect the process, such as the use of the filibuster. There used to be the role of the filibuster, but the nuclear option was used in recent years to lower the threshold for ending debates on Supreme Court nominees. So no longer the cloture motion to end a filibuster for normal legislation is 60 votes, which means that you need 60 votes effectively, because otherwise it can easily be filibustered. The nuclear option was used to lower this down to 50. So effectively a simple majority, only a simple majority is required to pass a Supreme Court justice. Brett Kavanaugh's 2018 confirmation involved a narrow Senate vote of 50-48 and then one from the Vice President after extensive debates, with Joe Manchin the only Democrat to vote in favour. Then the final stage is appointment. So if a nominee is confirmed by the Senate, they're officially appointed to the Supreme Court and can begin their tenure as a justice. The justice takes 2 oaths, to the Constitution and to the judiciary, before assuming their duties. In terms of examples of this appointment process, so Ketanji Brown Jackson, her appointment to the Supreme Court followed the retirement of Justice Stephen Breyer, and Biden nominated her, making her the first black woman to be selected for the court. Her Senate confirmation was a significant moment, passing with 53-47 on April 7, 2022. All 48 Democrats, 2 independents, and 3 Republican senators, so Susan Collins, Lisa Murkowski, and Mitt Romney, who were the kind of 3 most moderate Republican senators, voted for her confirmation, while the remaining Republicans opposed. The hearings leading up to the vote scrutinised her judicial record, philosophy, and past role as a public defender, and in particular, Republicans questioned her sentencing decisions in child pornography cases, arguing that they were too lenient, and how her defence of Guantanamo Bay detainees might influence her Supreme Court rulings. In terms of Amy Coney Barrett, her appointment process to the Supreme Court was sped up by the Republicans to ensure that she was appointed prior to the 2020 presidential election. She was confirmed by a Senate majority of 52-48, almost entirely along party lines. Her hearings focused on her judicial philosophy, past rulings, and views on healthcare and abortion in particular, reflecting the court's potential ideological shift with her appointment. Critics focus on her potential influence on healthcare and abortion, noting the rushed nature of hearings and contrasting it with the delayed consideration of Merrick Garland in 2016. Despite the controversy, Barrett's confirmation reflected the intense partisan atmosphere at the time. Brett Kavanaugh's confirmation to the Supreme Court was one of the most contentious in history, marked by allegations of sexual assault dating back to his high school and college years. The hearings were intensely polarised, with emotional testimonies and fervent political debates. Kavanaugh defended his innocence and suitability for the court. Ultimately, he was confirmed by a very narrow margin of 50-48, reflecting the deep divisions within the Senate and the country over his nomination. And his appointment solidified a conservative tilt in the Supreme Court. Only one Democrat, Joe Manchin, voted in favour of his confirmation, while the majority of Republicans supported him, despite these allegations. And then a key example of an appointment process which wasn't successful is Merrick Garland. So he was nominated to the Supreme Court by Barack Obama in 2016 after Justice Antonin Scalia's death. Despite his moderate record and extensive judicial experience, the Republican-controlled Senate under McConnell argued that the next president should fulfill the vacancy given the election years. This was really breaking with precedent, and sought as kind of a creation of a justification when it was in reality clearly motivated by political means and the fact they wanted to ensure that the Supreme Court was as conservative as possible. This led to an unprecedented stalemate, with no hearings or vote for Garland, leaving the seat vacant until Trump was elected later in the year, and he appointed Conservative Justice Neil Gorsuch. It marks a significant moment in the politicisation of the Supreme Court nominations, still resonating in discussions about the court and its appointment process today. And this kind of really links into the fact that the appointment process has become increasingly politicised and polarised over recent decades. Historically, confirmations were a lot less contentious, with nominees often confirmed with overwhelming bipartisan support. For example, Antonin Scalia in 1986 was confirmed 98-0. By contrast, as we've seen, more recent nominations have seen much narrower margins and more strict party line voting, reflecting heightened political tensions, and the fact it's seen as a key political issue rather than kind of just a judicial appointment. And Amy Coney Barrett was the first appointment since 1870 to receive no votes from the opposing party. This shift is arguably due to the growing perception of the court as a key arbiter in key issues in US politics and US life, like abortion, gun rights, and healthcare. And the polarisation is further exacerbated by the lifetime tenure of justices, making each seat highly, highly important for the ideological balance of the court for decades to come. And as a result, parties increasingly view appointments as high-stakes battles, leading to more strategic considerations in timings, nomination battles, and public campaigning around the appointments, significantly diverging from the more deliberative and less partisan process of the past. And what we just looked at, Merrick Garland's nomination kind of exemplifies the fact the politicisation of the process. Refusing to consider his nomination during an election year, the Republican-controlled Senate left the seat vacant for nearly a year. This was a big departure from tradition and showed that the kind of appointment process was used strategically to influence the court's ideological composition. Okay, so that was the appointment process to the Supreme Court. What we're going to have a look at now is the factors that influence the president's choice of nominees. And the first and arguably most important one is ideological alignment. So presidents typically seek a Supreme Court nominee whose judicial philosophy aligns with their own ideological stance. And this ensures that the court's future decisions might reflect the president's views on key legal and constitutional issues. A conservative president, so Republicans often, will likely nominate someone with a record of conservative rulings, whereas a liberal president, often Democrats, will look for a candidate with a progressive judicial philosophy. For example, Amy Coney Barrett was seen to solidify a conservative majority on the court, chosen by Trump specifically for her conservative judicial philosophy and potential to influence key decisions on healthcare and abortion rights, the latter of which she crucially did when the court voted to overturn Roe v. Wade in 2022. Brett Kavanaugh, similarly, was appointed by Trump for similar reasons due to his solid conservative credentials and expected alignment with conservative positions on regulatory, environmental, and social issues. Presidents have to be careful, as sometimes justices can surprise them by making decisions that weren't expected of them. So Justice David Souter, appointed by George H.W. Bush, for example, was expected to be a conservative voice, but often sided with liberal justices on issues including abortion rights and affirmative action, surprising and disappointing many conservatives who had supported his nomination. The next key factor is the potential for Senate confirmation. So the likelihood that a nominee will be confirmed by the Senate is a crucial consideration. And this involves assessing the current political composition of the Senate and the potential for bipartisan support. A president may opt for a more moderate nominee if the opposing party controls the Senate to increase the chances of confirmation. Cantor G. Brown Jackson was chosen by Biden not only for her qualifications, but also for her potential to appeal to both moderates and progressives in a closely divided Senate, due to her commitment to justice reform but distinguished career, leading to a successful confirmation. This also links in to legal qualifications and experience. So nominees are generally expected to have a distinguished legal career, often with experience as judges, lawyers, or law professors. And their past rulings, legal writings, and overall reputation are closely examined in the Senate hearings. This criterion ensures that the nominee possesses the kind of required knowledge, expertise, and temperament necessary for the role. So Eleanor Kagan's nomination by Obama capitalized on her reputation as a brilliant legal scholar and her experience as the first female Solicitor General, reinforcing the administration's emphasis on a diversified yet qualified court. Neil Gorsuch, with his robust judicial record on the 10th Circuit, was presented by Trump as a highly qualified and respected legal mind, ensuring a smooth confirmation process. Demographic considerations for diversity are also considered, so presidents consider diversity in race, gender, and cultural background as an important factor. And this is aimed at ensuring the Supreme Court, as a key body in the United States, reflects the diverse makeup of the nation and brings a variety of perspectives to legal interpretations and decisions. Biden's appointment of Jackson was a historic move, aiming to bring racial diversity and representation of women to the Supreme Court, reflecting a broader commitment to inclusivity. And the final thing is the current composition and needs of the court. So the existing makeup of the court in terms of ideological balance, legal expertise, and age can influence the president's choice. For instance, they might nominate a younger justice to ensure a long-lasting impact, or choose someone with expertise in a specific area of law that is underrepresented on the court. So Barrett's relatively young age of 48, an appointment made her influence on the court's decisions would extend for potentially 3, 4, potentially even more decades. A strategic move by President Trump to maintain a long-term conservative influence on the judiciary. Okay, what we're going to have a look at now is the strengths and weaknesses of the appointment process. So on the one hand, key strengths is that there's thorough vetting, as we looked at. So nominees' qualifications, judgments, and writings are examined, involving the American Bar Association, but also by Senate judiciary hearings. This reflects the fact that it has to be confirmed by the Senate, and there's these Senate judiciary hearings. Reflects that it also involves checks and balances, where the President and Congress both have to agree. And that shows the kind of checks and balances and separation of powers in the US Constitution. It can also be used to promote diversity and correct historical imbalances on the court. Lifetime tenure can be argued to be a positive thing, as it ensures independence and ensures that they're free. Justices are free from immediate political backlash or concerns about job security, which can allow them to be independent. And finally, it can be argued to be good because it's democratic, because ultimately it's Congress and it's the President who decides who's on the court. And because the court is very important in upholding the Constitution and influencing the politics of the United States, it can be argued that's right that they're kind of in a way elected or appointed by democratic means, not by democratic means, but by those who are elected by the public of the United States. In terms of weaknesses, the process is extremely partisan. So it's become extremely susceptible to partisanship, with presidents pursuing ideological alignment with their party's base over qualifications and merit. This can be seen in the fact that in recent years you've had a lot more party line voting in relation to confirmation of nominees, whereas in the past they were often passed with bipartisan support. There's crucially also unpredictability in vacancies. So unlike many other high courts worldwide, the US Supreme Court lacks a mandatory retirement age for justices, which there is in the UK, for example. And this can lead to unpredictability in vacancies, as justices can serve well into their old age, potentially facing health issues that affect their ability to perform their duties effectively. And this unpredictability leads to some presidents being able to appoint many justices and some very few. For example, Obama, who's a Democrat, likely to appoint liberal justices, was only able to make 2 successful appointments in 8 years, whilst Trump was able to make 3 in 4 years, just because of the kind of unpredictability and luck involved in vacancies. In some cases, political compromises during nominations has resulted in less qualified candidates being appointed to the court. And these compromises can prioritise political expediency over the court's competence and quality of the justice delivered. This can be seen in the nomination of Harriet Miers by Bush in 2005. So Miers, who had served as a White House counsel, lacked a strong judicial track record and faced criticism for her qualifications. And the nomination was seen as a result of political considerations, and it ultimately actually faced significant opposition, and she was withdrawn from consideration. Increasingly, there's long, political and contentious confirmation hearings, which are kind of seen as a kind of key partisan battles in a political battleground, rather than substantive evaluation of the nominees. And crucially, linking in to the fact that it's very partisan, it's very much perceived by the US public as being very politicised. And it's about politics and about power plays, and that really undermines its kind of key role as a neutral arbiter and a judicial institution that's supposed to uphold the Constitution and check the powers of the other branches. So therefore, it kind of potentially risks undermining its legitimacy and undermining the rule of law. What we're going to have a look at now is how the ideological balance of the court has changed over time in response to appointments. So first, when we're talking about ideological balance, what do it mean? So conservative justices often emphasise an originalist or textualist approach, interpreting the Constitution as it was understood at the time of its inception. They generally advocate for states' rights, a limited federal government, and a pro-business stance, aligning with many Republicans' emphasis on free markets and individual liberties. Their rulings often reflect scepticism towards progressive social policies and regulations, mirroring Republican priorities for strict constitutional adherence, traditional social values, and judicial restraint. And they typically approach issues like abortion and affirmative action with a preference for more restrictive policies. There's a strong political and legal alignment between conservative justices and Republican beliefs. By contrast, liberal justices often adopt a living constitutional approach, adapting the Constitution to contemporary values and societal needs. They often champion expansive civil liberties, affirmative action, and reproductive rights, reflecting democratic ideals of social justice and equity. There's a notable alignment between liberal justice rulings on issues like abortion, where they upheld precedents like Roe v. Wade, and democratic principles. And their decisions usually favour broad interpretations of rights and of federal powers, supporting government intervention in promoting individual welfare and equality across the US. And these justices are generally open to considering societal changes, aligning with democratic views, progressive reform, and judicial activism. So that's kind of what conservative and liberal justices mean, and what we're going to have a look at now is the shifting ideological balance of the court over time. And that's effectively since World War II. So since World War II to the 1960s, what you had was the Warren Court, and this marked a significant liberal era under Chief Justice Earl Warren, where the court expanded civil rights, civil liberties, judicial power, and the federal government's role in addressing social issues. So cases such as Brown v. Board of Education and Miranda v. Arizona epitomise this period of progressive judicial activism. And then, from the late 60s to the 1980s, you had the Burger Court, which served as a bit of a transitional period with mixed rulings. It upheld many of the Warren Court kind of liberal decisions, but also reflected a more conservative shift on issues like criminal justice. Landmark decisions, though, like Roe v. Wade, demonstrate this nuanced position between liberal and conservative ideologies. So this was more of a liberal ruling. From the 1980s to the early 2000s, you had the Rehnquist Court, which marked a clear conservative shift, emphasising state rights, a limited role of the federal government, and a restrained judicial approach. We saw significant ruling of federalism, the Commerce Clause, and social issues, reflecting a more conservative judicial philosophy. So that Commerce Clause one was the Lopez case that we mentioned in the Constitution videos earlier on the channel. And finally, since 2005, what you've had is the Roberts Court, which has continued the conservative trend, especially with recent appointments. So under Chief Justice John Roberts, the court has made significant rulings on healthcare, voting rights and campaign finance, further solidifying a conservative majority. And the appointments of Gorsuch, Kavanaugh and Barrett more recently under Trump have marked a real solidification of this conservative influence in the past decade. And the final thing we're going to have a quick look at is the current composition and ideological balance of the court. In terms of the court as a whole, there's currently a 6-3 Conservative majority, with 6 justices appointed by Republican presidents and 3 justices appointed by Democratic presidents. And in line with this, the ones appointed by Republican presidents are generally considered to be conservative, and the ones appointed by Democratic presidents are generally considered to be liberals. And we'll have a look at each justice. So John Roberts, who served as the Chief Justice since its appointment by Bush in 2005. He was initially nominated to replace Justice Sandra Day O'Connor, but was instead nominated for Chief Justice following the death of Chief Justice William Rehnquist. Roberts is known for his work in maintaining the integrity and reputation of the court, often serving as a swing vote in closely divided cases, and sometimes siding with liberals on the court despite being a moderate conservative. His confirmation process was relatively smooth, reflecting his broad legal experience and respect across the political spectrum. Clarence Thomas, appointed by George H.W. Bush, has served on the Supreme Court since 1991. His confirmation process was one of the most contentious in history, marked by intense debate and televised hearings involving allegations of sexual harassment from former colleague Anita Hill. Despite the controversy, Thomas was narrowly confirmed and has since become a stalwart conservative on the court, known for his very kind of textualist, originalist approach to constitutional interpretation. Samuel Alito was appointed by George Bush and has been a justice since 2006. His confirmation followed a contentious process with some filibuster threats and substantial debate over his conservative judicial philosophy. Ultimately, he was confirmed with a relatively close vote, reflecting the partisan divisions of the time. He's known for his detailed legal reasoning and known for his conservative views. Sonia Sotomayor was appointed by Obama in 2009, becoming the first Latina justice. Her appointment was celebrated as a significant step for diversity on the court and followed a generally supportive confirmation process, though it did involve detailed scrutiny of her extensive judicial record and public speeches. She's known for her kind of advocacy for civil rights and criminal justice reform. Also appointed by Obama in 2010 was Elena Kagan, again another liberal justice. And her confirmation process was notable for her lack of prior judicial experience, having served as Solicitor General of Dean of Harvard Law School. Despite some debate over her experience and academic writings, Kagan was confirmed with a majority of the Senate's support, reflecting her legal acumen and potential for consensus building on the court. And then we've got the key ones appointed in the last 5 or 10 years. So Gorsuch was appointed by Trump, has been on the court since 2017. He kind of replaced Antonin Scalia and followed a kind of significant political showdown, including the Senate's refusal to consider Obama's nominee Merrick Garland. So Gorsuch was kind of immediately appointed after Trump because there was this vacancy since mid-2016 when the Republicans refused to appoint Merrick Garland, who was Barack Obama's nominee. So it was a really important appointment because it solidified the court's conservative tilt and reflected his reputation as a principled conservative jurist. Kavanaugh, appointed by Trump, as we kind of mentioned earlier in the video, is a very kind of divisive appointment process due to the fact that there were strong allegations of sexual assault against him. And after an initial FBI investigation and heated Senate debates, Kavanaugh was confirmed with one of the slimmest margins in history, reflecting the deep partisan divide of the time. So only 50 voted for him, and it had to be confirmed. There had to be a vote by the vice president, and only one Democrat, Joe Manchin, voted for him. Barrett was appointed by Trump and has been on the court since 2020. Again, she's a very conservative she had very much conservative leanings, and her appointment solidified a 6-3 Conservative majority on the court, and was a testament to her strong Conservative credentials and judicial philosophy. So effectively a strict party line vote in her nomination, with no Democrats voting for her. And the most recent appointment is Ketanji Brown Jackson, who was appointed by Biden in 2022, becoming the first black woman on the Supreme Court. She's a strong liberal voice on the court and appealed to both moderate and progressive supporters of the Democratic Party, and she had a strong kind of experience as a federal public defender. But she replaced a liberal member of the court, so it continued to be a 6-3 Conservative majority on the court. Final thing we'll have a look at then is how there have been recent Conservative rulings by the court. We're going to look at this in more detail in the next video on the Supreme Court and public policy. The key, kind of one of the most important ones, is on reproductive rights, with Dobbs versus Jackson Women's Health Organization in 2022, which overturned Roe v. Wade, removing the constitutional right to an abortion, and effectively giving the power and decision-making in relation to abortion back to the states. In terms of religious freedom, the court has tended to side with protecting religious expression, after expanding the rights of religious organizations and individuals. And this includes rulings that have allowed for more religious presence in public spaces and more robust protections for individuals and businesses to refuse services based on religious beliefs affecting debates on topics like LGBT rights and healthcare provisions. In Fulton v. City of Philadelphia, there was a significant victory for religious liberty advocates, where the court unanimously ruled that the City of Philadelphia violated the First Amendment when it froze the contract of a Catholic foster care agency that refused to work with same-sex couples. The court's also made a number of really important decisions in relation to voting rights, election laws, often with significant implications for electoral politics. So it's upheld voter ID laws and other voting restrictions, contributing to debates over voter suppression and the accessibility of voting. Whilst the court's rulings on gerrymandering have shaped the political landscape, sometimes criticised for enabling partisan redistricting. And what they've effectively said in relation to gerrymandering is that it's up to the states to decide. In Brnovich versus Democratic National Committee in 2021, the court upheld Arizona's contested voting restrictions, including the discard of ballots cast in person on election day outside of the voter's designated precinct, despite criticisms that these practices discriminated on the basis of race. And this ruling was made with a 6-3 Conservative majority. So that shows how the kind of ideological leanings of the court are really important in making decisions. The final couple are gun rights and environment regulations. So on gun rights, the court has continued to support an expansive interpretation of the Second Amendment, striking down gun control measures in several instances. This has reinforced the right to individual gun ownership and bearing arms, and the constitutional right of the Second Amendment based on individual ownership rather than kind of collective self-defense as a militia. And in terms of environmental regulations and business interests have also been a key area of the court's rulings, and it's often decided in favour of limiting the regulatory powers of the federal agencies over businesses, affecting policies on climate change, pollution, and the balance between environmental protections and economic interests. In Sackett versus the EPA in 2023, the court limited the EPA's regulatory jurisdiction, specifically regarding wetlands. And the ruling determined that the EPA's authority under the Clean Water Act extends only to wetlands with a contiguous surface connection to waters of the United States, representing a significant decision in the balance between environmental protection and property rights, and kind of the upholding of business interests over the interests of the environment. So yeah, that's everything in relation to the appointment process for the Supreme Court. Let me know if you've got any questions or comments in the comment section below, and I'll be back with the next video on the Supreme Court and public policy.